Hi, this is Dave Bliven, Bronx and Westchester divorce attorney with another episode of Lessons from the Divorce Wars. So this lesson comes in from a client I represented a few years ago. He had a custody case. At the time he came to me, he said, for the most part, the mother and I get along with respect to the child, but she's a little nuts. So at times we argue, we have disagreements, but I think we can work things out in terms of joint custody, visitation, etc. So we file the case, we get into court. All of a sudden the mother retaliates, files a custody case, files an application to have his visits supervised, and files a petition for a family offense, otherwise known as an order of protection. So the lesson in this case is, especially if you somewhat suspect that the other side is a little nuts, you want to be making a very careful paper trail, which means emails are better than texts, texts are better than nothing, but a paper trail capturing important conversations, pick up and drop offs that go wrong, other threats or anything like that the other side says to you. You really want to keep that paper trail going. And sometimes I have potential clients say, the other side, they may not answer me. Well, silence equals acceptance. So if you send an email or text to the other side capturing an event from your perspective or a conversation and the other side doesn't respond, that's still admissible in evidence. So still do it. I don't often advise, to throw a cell phone up in somebody's face and video record them. Some judges may construe that to be harassing in nature, especially if you're very close to the person. But you can audio record conversations, video record at a respectful distance, but keep that evidence chain going. Even suggest that the other side participate in a parenting app such as Our Family Wizard to better organize and capture those conversations going back and forth. And that way nothing is, or very little, will be a surprise when you get into family court. You don't want to be taken aback when you're thinking you're going to work things out in family court and all of a sudden you get in there, find there's an order of protection against you and your visits are now supervised. And consult an attorney at the earliest opportunity you have when you start seeing issues are going bad between you and the other side. So those are just some lessons to take away and help you better prepare for a custody or visitation case. For more answers to questions like these, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.